Major Supreme Court ruling.
Major ruling involving the Second Amendment.
The Supreme Court will be taking up a gun rights case
On New York's concealed carry regulations.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision.
It's a case that legal experts will be watching closely.
Picture this. You wake up tomorrow morning and a legal framework that's controlled American gun rights for over a century just evaporated overnight. Not through some gradual political process, but through a single Supreme Court decision that nobody saw coming. And what makes this even more shocking is that the very government agencies who spent decades enforcing these restrictions are now quietly stepping aside, refusing to defend the system they once championed. A 6-3 Supreme Court ruling just sent shockwaves through America's legal landscape, and the implications are so massive that even seasoned constitutional lawyers are struggling to grasp the full scope. This isn't some narrow technical ruling that only affects a few states. This is a fundamental redefinition of how constitutional rights work in America, and it's already triggering a cascade of changes that's reshaping the legal battlefield in real time. States are scrambling to rewrite their laws. Law enforcement agencies are caught in bureaucratic chaos. Gun control organizations are launching emergency campaigns. And a multi-billion-dollar industry built around permit gatekeeping just watched its foundation crumble before their eyes. Here's what nobody's telling you. This moment has been building for over a decade. And what just broke isn't just a legal precedent. It's an entire philosophy about whether Americans need government permission to exercise their constitutional rights. The case that changed everything. The lawsuit that demolished over a century of permit gatekeeping was New York State Rifle and Pistol Association versus Bruen. And it went straight after New York's infamous proper cause requirement that had been strangling gun rights since 1911. New York forced every concealed carry applicant to prove they had a special reason beyond ordinary self-defense to carry a firearm in public, and the bar was set impossibly high. Simply wanting to protect yourself or your family didn't cut it. You had to document active threats against you, prove you were being stalked with evidence, or show that your job put you in unique danger that ordinary citizens don't face. And even with all that documentation, the final decision still came down to one bureaucrat's personal opinion about whether you deserved constitutional protection. In June 2022, the Supreme Court ruled 6-3 that this entire licensing scheme violated both the Second and 14th Amendments. Justice Clarence Thomas established a brand new legal framework that if a law restricts your Second Amendment rights, it must be rooted in the Constitution's text, history, and tradition, not what modern politicians think sounds reasonable or what polls well with voters. This wasn't just a victory for New York gun owners. It was a constitutional earthquake that would reshape gun law across the entire country, the domino effect across America. When Bruen came down, it didn't just strike down New York's law, it instantly invalidated nearly identical may-issue systems in California, New Jersey, Hawaii, Maryland, Massachusetts, Delaware, Rhode Island, and Washington, D.C. that all relied on the same subjective approval process. Before this ruling, these 9 jurisdictions collectively denied somewhere between 60 to 70% of concealed carry permit applications from ordinary working citizens. While celebrities, retired law enforcement, wealthy business owners, and politically connected individuals somehow sailed through the process without issue, creating a blatant two-tier system where your constitutional rights depended entirely on your social status or who you knew. Now every single one of these states is being legally forced to transition to shall-issue systems, which means if you meet objective legal requirements like passing a criminal background check and completing required training, the state must approve your permit without any subjective judgment calls from licensing officers. Hawaii is a perfect example. Before Bruen, the entire state had issued fewer than 200 active concealed carry permits to civilians. But after the ruling, they've been forced to process thousands of new applications. And early data shows approval rates have rocketed from single digits to over 80% in counties that previously denied almost everyone. The revenge law is being passed. Anti-gun state legislatures aren't accepting the Supreme Court defeat quietly. They're fighting back with what legal experts are calling malicious compliance. And the backlash is more coordinated and aggressive than most gun owners realize. California immediately responded by mandating 16 hours of hands-on training that costs applicants anywhere from $200 to $400 depending on the county, plus application fees that now exceed $150 in some jurisdictions. And they've deliberately extended processing times from a few weeks to 6 months or longer, effectively creating a financial and time barrier that prices out working-class citizens who can't afford to miss multiple days of work or pay hundreds of dollars in fees. New York struck back by passing emergency legislation that designates such an absurdly broad list of sensitive places where concealed carry is banned that permit holders effectively can't carry anywhere in the state. The prohibited zones now include Times Square, every form of public transportation including subways and buses, all public parks and playgrounds, any bar or restaurant that serves alcohol, libraries, entertainment venues, houses of worship, and even private property unless the owner posts explicit signage permitting firearms, which virtually nobody does. New Jersey introduced requirements for liability insurance, multiple character references, and social media account disclosure going back years, essentially turning the permit application into an invasive background investigation that's designed to intimidate people into not even applying. These aren't good faith attempts to comply with the Supreme Court's constitutional mandate. These are deliberate, calculated strategies to circumvent the ruling by making it functionally impossible for ordinary citizens to exercise their rights, the new constitutional standard. The most powerful and far-reaching part of the Bruen decision isn't what it struck down. It's the entirely new legal test it created for evaluating every single gun law in America. Moving forward, courts must now apply what's officially called the text, history, and tradition test, which requires that any regulation restricting Second Amendment rights must be consistent with how firearms were actually regulated during America's founding era in the late 1700s and early 1800s. Modern policy arguments about public safety or crime statistics are no longer legally relevant. This is a complete reversal of how gun cases were decided for decades, where judges used interest balancing tests that weighed gun rights against government claims about safety, which almost always resulted in upholding restrictions. Now the burden has completely flipped. The government must prove that historical analogs to any modern gun law existed during the founding period, and if prosecutors can't produce clear historical evidence from that specific era, the law fails constitutional scrutiny, and that's an incredibly high evidentiary bar that most gun control measures simply cannot meet. Since Bruen was decided, federal courts across the country have already struck down magazine capacity limits in California, assault weapon bans in multiple states, certain concealed carry restrictions, and firearm transportation regulations, specifically because government lawyers couldn't produce founding-era historical evidence that justified those modern restrictions. The gun law is now in the crosshairs. Because of the strict new historical standard that Bruen established, dozens of gun control laws across the country are now facing constitutional challenges that they would have easily survived just 3 years ago. Magazine capacity limits that restrict firearms to 10 rounds or less, currently enforced in 9 states affecting over 90 million Americans, are being challenged in federal court because there's absolutely zero historical evidence that founding-era Americans ever limited ammunition capacity. Multiple federal judges have already ruled these magazine bans unconstitutional under the new test. So-called assault weapon bans that prohibit certain firearms based purely on cosmetic features like pistol grips, adjustable stocks, or barrel shrouds are collapsing in court because the government cannot demonstrate that colonists or early Americans ever banned specific rifle configurations. California's decades-old assault weapon ban was struck down by a federal court and is currently on appeal. Mandatory waiting periods of 10 days or more before taking possession of a firearm, even for people who already own multiple guns and have passed numerous background checks, are being challenged as having no founding-era historical precedent. Courts are seriously questioning how forcing someone to wait serves any legitimate constitutional purpose when they've already been vetted. What changed for permit holders? For gun owners living in constitutional carry states like Texas, Florida, Arizona, Tennessee, Wyoming, or Montana, the Bruen ruling doesn't fundamentally change your day-to-day reality because these states already respected Second Amendment rights with straightforward objective permitting systems or constitutional carry that doesn't require permits at all. But for the estimated 25 million Americans living in the 9 restrictive may-issue states who were previously denied permits under arbitrary proper cause requirements, this Supreme Court decision is genuinely life-changing. They can now legally carry firearms for self-defense without having to prove special danger, document threats, or have political connections to get approved. Permit application numbers have absolutely exploded in formerly hostile jurisdictions, with some counties reporting 300 to 500% increases in concealed carry permit requests within just months of the Bruen decision being announced. Approval rates have jumped dramatically from under 10% to over 75% in places that used to routinely deny ordinary working citizens as a matter of policy. However, getting a permit approved doesn't automatically mean that carrying is suddenly easy or practical. because many of these states responded to Bruen by implementing sensitive place restrictions so sweeping and broad that legal concealed carry is functionally impossible throughout most urban areas. Some permit holders report that after mapping out all the prohibited zones, they can only legally carry their firearm in their personal vehicle and inside their own home. The battle that's just beginning. The real constitutional battle isn't over concealed carry permits anymore. That specific fight is essentially won at the Supreme Court level. But the war continues over how far the text, history, and tradition standard extends to every other category of gun regulation. And that fundamental question will define Second Amendment law for the next generation of Americans. Lower federal courts across the country are currently split on how to interpret and apply Bruen's historical test to different types of restrictions, with some federal judges interpreting it broadly to strike down numerous gun control laws, while other judges apply it as narrowly as possible to preserve as many existing restrictions as they can, creating a chaotic patchwork of conflicting rulings across different federal circuit courts. The Supreme Court will eventually have to step back in and provide additional clarity on how the historical test actually works in practice, particularly when dealing with modern weapons in situations that literally didn't exist in the 1700s. Things like semi-automatic rifles with detachable magazines, standard capacity magazines holding more than single-shot capacity, and concealed carry in locations like airports, government buildings, or public transportation systems. Legal scholars estimate there are currently over 300 active federal lawsuits challenging various gun laws under the Bruen framework right now, covering everything from age restrictions that prohibit 18 to 20-year-olds from purchasing handguns to lifetime firearm prohibitions for nonviolent felons to good moral character requirements for permits. And the outcomes of these cases will fundamentally reshape American gun law as we know it. This Supreme Court ruling handed gun owners the biggest constitutional victory in decades. But the fight to preserve it isn't happening in headlines, it's happening in courtrooms, state legislatures, and permit offices right now, and most people have no idea how aggressively anti-gun politicians are working to undermine it through bureaucratic warfare and legislative workarounds. Constitutional rights mean nothing if you don't know them, use them, and fight for them when they're attacked. Gun owners now determine how far this ruling actually goes, which means tracking every new local ordinance that tries to sneak restrictions back in, showing up at city council meetings when they vote on carry bans, supporting the legal groups taking these fights to federal court, and continuing to carry responsibly, legally, and without apology. The revolution in gun rights isn't coming, it's here, and what happens next depends entirely on whether Americans understand what they've won and are willing to defend it against the inevitable counterattack.